Hello, today is Friday, June 7th, 2019. My name is Wilson White, and this is
Rhett Banfield with Carr and Carr Attorneys.
And we're going to be talking today about kind of what makes a case go to trial or what makes a case have to go to trial. Rhett and I are in the claims department. I am the head attorney here in the claims department. I've got 29 years of law experience. And Rhett, how many years do you have?
About 32 years.
32 years.
Both with the insurance industry and here at Carr and Carr.
Right. Rhett and I have a good ability with our feel with the insurance industry because I was a former insurance defense attorney for 13 years. And Rhett, how long were you?
21 years handling cases and litigation, managing litigation cases with Farmers Insurance.
Great, great. And real quick for the overview is the bulk of the cases that we receive here at the office and we sign up are able to be settled in the claims department. But as Rhett and I will tell you and explain to you, there are always some reasons why they might not, why they can't get settled. Rhett, what are some of your views on why some of the cases can't get settled?
Probably, the main ones will be if there's a liability dispute.
Right.
Who's at fault in the accident? The other side's contesting that. That's one reason. Another reason could be damages. They're questioning, are these injuries truly related to this accident? And those are some of the reasons that can push a case to the trial.
Right. And what we find also is a lot of people have pre-existing issues where they've had treatment with their back previously. And in my experience, sometimes those are harder cases to settle just because the insurance company always believes that the wreck didn't cause any problems, any injuries, and they just don't want to pay the fair value.
Okay. So, Wilson, you've always been a trial attorney. How many years?
29 years.
29 years and had your share of trials.
I've had my share of trials, workers' comp cases, civil cases, federal court cases. I've been all the way up to the 10th Circuit in Denver and completed oral arguments before a three-judge panel up there. So I've run the gamut for a long, long time.
So main question we get when we do talk to our clients and we may reach an impasse with the insurance company or whoever we're dealing with, unable to settle your case, is if we go this route through litigation, how long is that process?
Well, Rhett, that's a great question, and that's a big issue. And what I've always said to clients to try to, get their expectations in check is that it's going to be 2 years minimum. And that's from the time you file moving forward. A lot of times clients can't understand that. They think that when you go down and file something with the courthouse, that you get to go to the front of the line, and it's just a matter of the judge calling you saying, here's your trial date. Unfortunately, that's not the process. So that's one of the reasons that we always have to, let people know about that. And what it comes down to is there are thousands of cases that are filed every year in the bigger counties, Tulsa County, Oklahoma County. So when you have a judge, might have a trial load of 2,000 or 3,000 cases, and not all of those, some of those are collection cases, some of those are mortgage cases, but some of those are car wreck cases. So a judge might have 500 or 600 car wreck cases on their docket, and it just takes time to get through all of the processes and everything like that.
So the time, like you said, can vary. And obviously then in the outlying smaller counties where maybe you just have one judge, it could even, his docket could even be more constricted.
It is. And also there's a law in the books that says that, especially in the smaller counties, that they always have to take the criminal cases first, and then the civil cases have the lower priority. And I know sometimes the criminal cases they'll swell, and then that takes away from the civil dockets. And so it's just sometimes harder to get into trial. And those are some of the things that you have to put up with when you do go to trial.
Great. So other than obviously the trial docket causing the time frame to push out, just what are some of the initial steps and the timelines as far as, like you said, some people think you go file a lawsuit and the case gets settled. Right. There's a long line of things and processes that have to take place before you even get to that point.
Correct. First thing, that when you file a lawsuit, it's called a petition. State court, federal court, it's called a complaint. And you then will send that out for service. You have to either send it by certified or with a process server. Once it's served, the other side has 20 days to file an answer. So of course you burn basically a month right there. And then after that, normally what will happen is the defense will send what's called discovery. And those are just a series of questions that you have to fill out. From the time you receive those, you have 30 days to fill those out and send them back. So again, we're into the 2 months, 2.5 months. After the discovery questions, which are, paper questions, they will then set what's called a deposition. And what a deposition is, it's a time that the attorney for the at-fault person will come in, they'll come to our office, they'll sit down with our clients, and it's basically a day they get to ask any and every possible question, anything related to the motor vehicle accident. And unfortunately, when you're scheduling depositions, you have to look at your schedule, your client's schedule, the other attorney's schedule, and sometimes you have to take a month or so to try to circulate dates. So you've got another month that you've burned. And then in that deposition, usually they come across some information and they have to then find out some more information. We have to collect medical records, medical bills, and those things all take time.
Okay. And I know as this process is going, because a lot of people, even though they get into the litigation process, are really unsure if they actually want to get into a courtroom. Right. So can negotiations be ongoing while this entire process and more information is being learned? Absolutely.
During the discovery process, everything is fluid and everything is ongoing. And normally in most times when you're in the discovery, after the discovery phase, which is kind of the tell me your story, the name, rank, and serial number, we also get to find out about the other side, the person at fault. We can take their deposition. You can still have negotiations going on back and forth. And then normally the court will always, and it's required, I know in Tulsa County, to have what's called a court-ordered mediation. And that is either court-ordered or you can agree to go to a private mediator, and you go in and you take a day or half a day and you try to get your case settled. Tulsa County has a great service that they offer that's actually a free mediation service. So, because normally you have to pay for a private mediation, which can be $500 to each party, $1,000. But in Tulsa County, you can get a free mediation, and attorneys have just offered their time or doing it as a kind of as a request to the court and everything. One thing I would like to point out in litigation is oftentimes one of the reasons, there's lots of reasons to go into litigation. There's lots of reasons not to go into litigation. And one of the things that people need to understand, once you go into litigation, the last offer is usually still on the table, but Rhett and I have seen cases where when it goes into litigation, all bets are off.
Yep, they'll pull that offer.
They will pull the offer, and it's not being improper or mean-spirited. It's just part of the process. And so sometimes when you have to go into litigation, a lot of our clients think, oh, if we file this, they're immediately going to roll over. They might not. And in fact, if they've offered money previously, they can take that offer off the table. So that's one of the reasons.
And start the negotiations back at zero.
Yeah, because you're dealing with a new set of people that are looking at it, new adjusters, new attorneys, and they might find something that they don't like about the case or the client or something like that. So that's one of the things that before we go into litigation, I think some people just decide, they hear the last offer was not what they think was good enough. We agree with you, but sometimes it's too easy to do the knee-jerk reaction of, well, let's just go file the lawsuit, because you've got to really understand everything that can go on. Another thing, and Rhett can tell you this, a lot of people think if we file a lawsuit, that insurance companies are afraid of litigation. And Rhett, what was your finding on that?
There is no, I mean, most companies now, in fact, employ in-house attorneys.
Right.
So they really have no additional costs. They're already, employees of the company, but Now, defense attorneys are just like us. I mean, if it's, if there's a trial or litigation, they are there to go the distance.
Yeah, they go to the distance. So if people can understand that it's going to take probably 2 years minimum, that there's hundreds and thousands of cases out there, and then it's not afraid of litigation. Because as Rhett knows, Farmers is one of the large, flagship named companies. They're multi-billion-dollar companies. So they're not going to get worried about a car wreck in Tulsa, Oklahoma, things like that. One other point I want to make, and Rhett and I counsel a lot of our clients, if you're going to go into litigation, you've got to understand that your life is going to be an open book. Yeah. And even in the claims processes, it's going to be a little bit of an open book, but we're always amazed at clients that are posting things on social media, Facebook, Instagram. Most of these insurance companies, one of the first things they're going to do
is they go copy immediately. Go to Facebook, go to any social media they can access, and they will save any information they find. And they have brought that to our attention many times.
We had a case where a young man was in the hospital
and did a Facebook
Live like this, and because of the technology, from his hospital bed, and he was talking about his reckless driving, and he was talking about that he was speeding, and he was talking about he was fighting with his girlfriend, and they were doing all these things. And so what happened is the insurance company called us, and they said, "Hey, we know you're on the file. We know you. We like you. You're a very respected firm." And they said, "We have already downloaded all of these things in information." Yep. And she named off like 4 or 5 critical pieces. And she said, "Hey, we're denying the claim, not only from what our investigation showed, but because of these admissions." So you really have to understand that this is a full contact sport. That when Rhett was an insurance and I was an insurance defense attorney, sometimes it's kill or be killed, and it's very professional, and people are courteous and like that. But it's a serious situation. So when you go into these things, you really need to understand, hey, we're ready, willing, and able to take cases. We just tried a case this week. We're ready. We have 11 attorneys in our Tulsa, Oklahoma City office. We try lots of cases, and we really work hard at it. But you have to realize that the other defense attorneys are trying just as hard for their client to get out with little or no money. The other thing too, we always want to stress about litigation, because there are so many questions, is there are no guarantees, and there are no guarantees in life. We've seen huge verdicts, we've seen small verdicts, and I kid people that the longer I practice law, sometimes it seems like I have fewer answers than when I first started. And I'm sure Rhett's got cases like that too.
You just never know you never know when you put your fate in the hands of 12 people what they're going to do with it. Correct?
Right. And the other thing too that Rhett and I are always amazed at, we've got some cases in the claims department that we think really highly of, great damages, and it's like pulling teeth. That the adjuster just doesn't see it. And then we've got other cases where we think not a lot of damage, good treatment, but they've had a really good recovery. So, and then the insurance companies will surprise us with their offers, and we're like, wow. And it's sometimes there's no rhyme or reason with it and everything like that. A lot of times people ask us too in litigation is, do I have to go and sit through court? And the answer is yes. You have to do that. We've got some of our clients that are great people, but are very nervous. They're very shy.
It's a stressful situation.
It's a stressful situation. And you have to understand that. And there's a lot of factors to put into, with deciding to litigation. A lot of the juries, most of the time in our jury system, in our trial system, we have a jury, and that's usually either 12 people, or sometimes it can be kind of a hybrid depending on the case, 6 or 8. But here's what's funny is normally the insurance company demands a jury. I know there's a lot of cases sometimes if I have a judge that I really know and really like and is fair, I probably get a better shake from the judge because I can do it faster and quicker and cheaper for the client. And I know pretty well the outcome I'm going to get is at least, acceptable. But insurance companies are the ones that want to have the juries. And the problem is that we usually delay the process. It will slow down the process and it will cost you more money. And those are always factors too about before you go into litigation and what's involved in the litigation and everything like that.
So as a plaintiff, say the case goes all the way to trial, what are people may want to know? I filed a lawsuit against this individual. I'm pursuing to recover my damages. What risk do I have if things don't go right?
Well, one of the risks, first of all, is you still owe your medical bills. And some of the doctors will not pursue you, but sometimes the hospital will say, hey, you went to trial, you didn't have a good outcome, you didn't get all the bills, we want our money. So they can still sue you. They can go after you in small claims court. Number two, there are also some ways that you could actually end up owing the other attorney money.
The other side.
The other side.
Okay.
Because you don't owe us any money if we have a case and we get a smaller offer than we think. But sometimes the other side will make an offer, and it's called an offer to confess. And let's say if they offer you $15,000 in writing, and you turn it down and you go to court and you only get 10, they can sometimes come in there and get what are called costs back, and that can be depositions, things like that, experts. So you don't want to go to court, turn down a decent offer, get less, and then so you're going to get less money than before. And oh, by the way, you owe $3,000 of costs. And the way the statute is written, it's not Carr and Carr owing money. It's actually the client, you, the named plaintiff, or you, the named individual. And that doesn't happen a lot, but it's something to think about. It's a risk.
It's a risk.
And a lot of times what people sometimes don't understand is there are risks to litigation. And it's not a carefree, scot-free, kind of situation. They don't, because again, they think, hey, it's a contingency case. I don't have to pay my attorney. And that's true. You don't pay us. But there are processes, and it's very rare, maybe 1 out of 100. But hey, it's something you need to look at and everything.
Cindy has a question kind of along the lines here. She wanted to know if she's in an auto accident, case goes to trial, who is responsible for paying? She says court costs, but I think it's more along the costs of the litigation. How's that taken care of, Wilson?
Well, what that is, for example, usually you have a filing fee, say $250, and we pay that up front. If we have to take a deposition of the other side, we have to go pay a court reporter, and we have to pay for their time, and then there's a booklet that they type everything up in. So that usually is $1,000. Again, we will pay that, but those costs are ultimately you, the client's responsibility. So if we have a case and we can get $15,000 at trial, you have to pay the cost back out of your share of the money, and then we have attorney fees that we get back. But ultimately, we do put in our contract that if we go to court and you don't get your costs back, then you can ultimately have some exposure on those. But the big one you got to worry about is there's a way rarely that you can owe the other side's costs. And that's what people just, I think, sometimes don't appreciate and don't understand. They think it's such a risk-free situation, but it's not, because you can still owe medical bills and you can still have the costs. And that's the other thing too. People don't understand litigation is expensive. A standard car wreck case can probably cost us minimum, I think, $10,000.
Yeah.
And what that is, you've got a filing fee, You normally have taken 2 or 3 depositions of fact witnesses, like eyewitnesses, things like that. And you've got to get an expert. And an expert is like your treating doctor. If you saw 1 or 2 doctors, you have to have a deposition, a video deposition of them. You have to pay the expert for his or her time. So by the time you do those things, it can easily be $10,000.
That's just in a standard. So then if you have to get a reconstructionist expert in, if you have to get a biomechanical engineer in.
And if it's serious and you've got a surgical recommendation, you usually have to have 2 or 3 doctors, a treating doctor, an expert, and those usually get to be $20,000 or $25,000. And again, those are just on basic car wreck cases that take 2 or 3 days. So I mean, litigation can be expensive. And that's just really something to look at and to look for. But the other thing too, just because you go to court, you try the case, and you have a great result, then there's always the appeal process. And that can drag on for years. And you can have a basic appeal, and you're probably talking minimum, I think, a year, and probably minimum 1.5 years. And it's not unusual for it to go 2 years. So when you've got a case and you're 4 years down the road from the anniversary of the accident, you still got medical bills over your head, and you still got collection companies calling you, and you still see it on your credit report, it can be a stressful situation. And so that's why we try so hard, and we work so hard for our clients in the claims department. Like I said, Rhett and I have over 60 years experience. We've got some crack staff. They're great. They work so hard, and we really try to work them as hard as we can to try to maximize the offer so that we sometimes don't have to, go into litigation. There's always some reasons why, deny the fault, he said, she said, things like that. But those are some things, to look at and everything.
And with that all being said, there are those cases that even though there may be an issue here or there, they may not fit the litigation process, partly because of what you've outlined, the cost and the expenses, and so those are things to consider.
Well, and it's tough for clients to understand sometimes is you can be, sitting at a stoplight, no fault of your own, hard impact, you're hurt, you're in pain, but sometimes when it's all said and done, there's really nothing you can do with that case past the claims department. Because if you have 6,000 or 7,000 in medical bills, you can't take 2 years and spend $10,000 of costs to go try a case like that. And that's sad that the insurance company knows that and will give sometimes less than good offers just because they
know that.
They know that because it's not cost effective. The court is not going to let you clog the court with cases like that. They're going to almost browbeat you into taking a settlement or going to mediation. And like I said, and those are the frustrating ones for us and for our clients.
Very much so.
And in a case like that, normally what we do is we just get as flexible as possible, try to get bill reductions across the board, and just, make the best of a bad situation, everything like that. So.
Well, there's a lot of information. Do we have any questions, any additional questions out there?
Rhett and I are always available. We'd be happy to talk to current clients or, prospective clients and just what it entails. I think Rhett and I have a really good feel after 60 plus years. We've been doing this a lot of times, and we've got thousands and thousands of cases between us.
Oh yeah. Well,
we've seen just about everything, heard just about everything, and there's some wild ones out there. But we work hard for our clients, and we appreciate them.
Yes, we do very much.
We also wanted to mention it's been a tough week or two in Tulsa and the surrounding areas, Muskogee. We hope everybody is safe and recovering from the floods. We had another big round of rain yesterday in Tulsa, over 4 inches. Up in Skytook, over 5 inches. Really hard hit areas. The ground is so saturated. Rhett lives out in Broken Arrow. I was visiting friends last night in the Alwaso, Collinsville area. The rain is just hitting and pooling and running off. It's got no place to go, and the ground is so saturated. So we hope that everybody's doing well and safe from that, and just be careful and turn around, don't drown.
Exactly. And if you can, I know there's a lot of our fellow Oklahomans recovering right now from that. If there's any way you can help, reputable charities. I know there's a lot of charities out there reaching out to these people, see if you can be of a help to our, our fellow Oklahomans that have had to go through all of this.
We are not going to have an Ask a Lawyer session in July. So our next one looks like will be the first week of August, Friday, August 2nd. We hope everybody has a blessed and safe summer, and hopefully the rain will stay away, the lakes will go down, and we can all get out there by the 4th of July.
Enjoy the holidays.
Great.
Appreciate you joining us today.
Thank you all. Have a great day.